Imagine going to work every single day with a medical device keeping you alive, hidden under your clothes, barely noticeable, rarely making a sound, and still being called out by your manager in front of your coworkers for causing a disruption. Not because you were late, not because your work was suffering, but because a small pump beeped for a few seconds and you stepped away for less than a minute to address it. That's the situation one young woman found herself in. And what happened next raises serious questions about employee rights, disability law, and exactly how far a manager can push before it becomes illegal. Let's set the scene here, because the details matter enormously. A 21-year-old woman works at a job in New York. She has a medical condition that requires her to use a feeding tube during her shifts. The device itself, the tube and the pump, is worn under her clothing. You wouldn't even know it was there just by looking at her. She also carries a small backpack that holds the pump. Over the course of about 4 years of employment, the pump has beeped and required her attention only a handful of times. We're talking a few occasions total, each requiring her to step away for typically less than a minute. This is not a dramatic situation. This is not someone disappearing for long stretches of time. This is a person managing a serious medical condition as quietly and efficiently as humanly possible while doing her job. And here's what makes this situation even more important from a legal standpoint. She did everything right from the very beginning. When she was hired, she disclosed her condition and provided medical documentation. Her accommodation was formally approved. Recently, HR reaffirmed that the accommodation is valid and that she has done absolutely nothing wrong. This isn't a gray area. The company has already recognized in writing that her situation is legitimate and protected. So why are we here? Because a new manager came in and decided he had a problem with it. Here's how things unfolded, step by step. After one recent incident where her pump beeped briefly as in seconds, and she stepped away immediately to handle it, her new manager sent her an email. In that email, he referenced disruptions on the floor and suggested that she should complete whatever she needs to do before her shift or in designated areas. Let that sink in. He was telling a person with an approved medical accommodation to essentially pre-schedule a medical necessity. That's not how medical conditions work. That's not how accommodations work. And as we'll discuss in a moment, that line of thinking is not how the law works either. But it didn't stop there. After that email, the manager began making comments whenever she stepped away from her workstation. Comments like asking whether she needs another break already. And here's the thing. She wasn't even stepping away for her medical device in those moments. She was going to the printer. She was using the restroom. Normal, completely ordinary things that every employee does throughout the day. Yet he was tracking her movements and making pointed remarks, creating a pattern of singling her out. Then he pulled her aside privately and asked her to explain how the device works and how often it would interrupt work. Think about what that request communicates. It communicates skepticism. It communicates that he views her medical condition as an inconvenience to be managed and minimized, rather than a protected characteristic to be respected. No employee should have to sit across from their manager and justify the existence of a life-sustaining medical device. And then came the final email, the one that is perhaps the most legally significant of all. In it, the manager acknowledged that HR may not be able to change anything. He's aware that HR has already weighed in. He's aware that the accommodation is valid. And then he wrote anyway that the situation is not ideal for team workflow and that she should be mindful of disruptions. He is on record saying that he knows the law isn't on his side and that he intends to keep making this an issue regardless. That email alone is a significant piece of documentation. HR was informed. HR said they would speak to the manager again. And that was essentially the end of their involvement, at least so far. She also briefly consulted with an employment attorney who told her to document everything and confirmed that the situation could become legally actionable if the behavior continues. Now let's talk about what's actually happening from a legal perspective, because this is where things get very important for anyone watching who might be in a similar situation. In the United States, the Americans with Disabilities Act, commonly called the ADA, prohibits employers from discriminating against employees with disabilities. This law applies to companies with 15 or more employees, and it requires employers to provide reasonable accommodations to qualified employees with disabilities, unless doing so would cause significant difficulty or expense, what the law calls undue hardship. New York State adds even stronger protections through the New York State Human Rights Law, and New York City adds yet another layer on top of that if this workplace is within city limits. A formally approved accommodation is not a suggestion, it is not optional, and it is absolutely not something a line manager gets to override because he finds it inconvenient for team workflow. What this manager is doing falls into a category that employment lawyers call interference with an accommodation. When a manager repeatedly questions an employee about their medical device, makes comments designed to make them feel like a burden, and sends emails that characterize a medical necessity as a disruption, even after HR has confirmed the accommodation is valid, that conduct starts moving into the territory of disability harassment and discriminatory treatment. There is also something called a hostile work environment claim under disability law. People often associate hostile work environment with sexual harassment, but it applies to disability discrimination as well. If the conduct is severe or pervasive enough to create an intimidating, hostile, or offensive working environment for someone based on their disability status, that can be illegal. Is this situation there yet? Maybe not on day one, but a pattern is forming, and patterns matter in law. Here's the key legal concept to understand: retaliation. If an employee exercises their rights under the ADA, for example, by requesting or using a reasonable accommodation, and then suffers negative treatment because of it, that is retaliation, and it is independently illegal. That means even if a court weren't ready to call the manager's behavior a hostile work environment yet, retaliatory conduct could still create legal liability for the employer. And comments designed to make an employee feel guilty or monitored for using an approved accommodation look a lot like retaliation. The fact that she has written emails from the manager clearly stating his position is enormously valuable. Those emails document that he is aware of the accommodation, disagrees with it emotionally if not legally, and has chosen to pressure her about it anyway. That's the kind of paper trail that employment attorneys work with. So what should someone in this situation actually do? First, document everything. Every comment, every email, every time you stepped away and what you were doing, every witness who was present. Write it down with dates, times, and any relevant details. Keep copies somewhere safe that your employer cannot access: your personal email, a home computer, a notebook you keep outside of work. Second, use your company's internal systems properly. HR has already been involved, and that's good. If HR fails to address it and the behavior continues, that failure itself becomes part of the record. It shows the company was on notice and did not act adequately. Third, consider filing a charge with the Equal Employment Opportunity Commission, the EEOC, or in New York, with the New York State Division of Human Rights or the New York City Commission on Human Rights, depending on where you work. Filing a charge doesn't automatically mean a lawsuit. It's a formal complaint that starts a process, and it creates an official record. Many employment discrimination claims require you to file with one of these agencies before you can sue in federal court, so understanding those timelines matters. Fourth, consult an employment attorney sooner rather than later. Many employment lawyers offer free initial consultations and work on contingency, meaning they only get paid if you win or settle. You don't need to commit to a lawsuit to get a professional opinion on where your situation stands. And fifth, and this is something people often overlook, don't quit. If this manager's behavior drives you out of a job you enjoy and are good at, a constructive dismissal argument may exist, but it's harder to prove than straightforward discrimination. Stay, document, and let the law work for you rather than walking away from your rights. The woman in this story said something that stayed with me. She said she genuinely enjoys her job and doesn't want to risk it. She's not rushing to sue anyone. She just wants to understand where the line is. And that's exactly the right mindset. Understanding your rights isn't about being litigious. It's about knowing when someone is crossing a line they are not legally allowed to cross. If this happened to you, if a manager is making your life harder because of a medical condition or disability, accommodation your company has already approved, do not assume you have to just live with it. You have rights, and those rights exist precisely for situations like this one. Comment below if you've experienced something similar, and share this video with anyone who needs to hear it. Subscribe if you want more real stories about employment law and how to protect yourself in the workplace. New videos every week, no fluff, just the information you actually need.